youth on your side. We both have lost on that battle. Today's presentation starts off with a review of case law. We like to start off the CLE with a review of case law because it's sort of a broad brush of all the topics that you'll be hearing today. You're about to hear a number of cases that some will be talked about in more detail later today by some of the other speakers, but these are all cases that have of note in eminent domain and some outside of eminent domain that have been decided over the past 12 months. I can tell you just from reviewing case law in other states, Florida is unique in that we do have as much appellate case law as we do in eminent domain. There is just an abundance of case law on the topic, and I think we're rivaled only by the state of California, just by the sheer number of appellate decisions. You can go to a lot of other states, and they just have a dearth of appellate authority on any eminent domain issues. So we are unique in that regard. Today we have three very significant cases to talk about, and they're not in order of importance. They're really in order of development in the outline that you have before you today. One case was decided by the Florida Supreme Court that is a seminal decision that will affect eminent domain litigation for the rest of the year, and that's the first case we're going to talk about. Another case will be decided by the Florida Supreme Court within the next year, and that too will be a seminal decision by the Supreme Court. And then the third case is going to be argued in front of the United States Supreme Court this December, and that too will be another groundbreaking decision. So we'll review those in detail, but I'm going to spend some time going through the ones that we do have in the outline. The first case we have is System Components Corporation versus Florida Department of Transportation. This is a business damage case that censure materials were submitted in August, has since been published in the official reporter. If you can see in red there in the outline, that's the official reported citation for anybody who's interested. It's 14 Southern 3rd 967. This was decided by the Florida Supreme Court. This is a unique case involving a wholesale distributor of fluid purification control and instrumentation system. So System Components was an organization that received different components, assembled them, and then distributed them to entities that would then use those fluid purification systems for other purposes. And the decision notes that there was virtually no walk-in business at this location. So when you, as a lawyer, that your eyes kind of gravitate towards that, you're wondering, well, how are you making a business damage claim in the first place if there's virtually no walk-in business? But in this case, System Components did make a business damage claim. They had claimed, as a result of a partial taking of their property by the Department of Transportation, that they could no longer operate at this location. And as a result, they were going out of business. Now, the reality is that System Components was moving to a new location. But the way case law was in Florida at that time, they were making a claim that their business had been wiped out and that they should be paid for the full wipeout value of around $2.4 million. The Department of Transportation argued otherwise and said, no, you're actually relocating to a new location. You should be paid the lesser amount of $1.4 million, which is your cost to relocate and reestablish your business. System Components undertook that relocation. There was all sorts of documentation to support what was involved in this actual relocation. So we weren't dealing with a hypothetical situation. They ended up leasing their property from the Department of Transportation for a temporary period of time, leasing some property from a third-party lessee. They ended up finding a new permanent site, and then they ended up hiring an architect and an engineer to reconfigure that site, and then someone to facilitate that move. So you had all these detailed facts about what was involved in the business relocation here. The Florida Supreme Court took this case up on conflict jurisdiction, conflicting with another decision from the 4th District Court of Appeal, this decision coming out of the 5th District Court of Appeal. And in the 4th DCA decision, Tire Centers, in Tire Centers, the appellate court said that the business owner was entitled to the wipeout claim. Even though they had actually relocated to a new location, they were entitled to the wipeout claim for business because they could no longer continue to operate at that location. The Supreme Court took this decision up and actually ruled in favor of the 5th District Court of Appeal and said, no, the actual extent of the harm suffered by the business is the foundation of the business damage award, and the business damages should only compensate you for the probable reduction in your business value. You shouldn't be compensated for something that hasn't actually occurred. You should only be compensated for what your actual losses are. And here the court took this as an opportunity to say that business damages were not intended to be a windfall unconnected with any out-of-pocket loss, which is how the department characterized the wipeout claim as opposed to the relocation claim. The court then went on to say that, to announce a rule that when a qualified partial taking destroys a business at a location and the owner actually does relocate, the business damages that result from that must be measured based upon the actual reality that occurred, not based upon some kind of hypothetical of staying in that location. And the court went on to pronounce certain components that that business damage claim can be made up of, such as relocation costs, increased debt, downtime, recovery period, as well as permanent productivity losses. Finally, the court said that the award has to be based upon the total cost and damage associated with relocation, and that total cost cannot exceed the value of the business. So if the business was only valued at $1 million and it cost you $1.5 million to relocate, your business damages would be capped at the lesser of the two. Finally, the court, and this was I guess the one thing that the department did not get in this appeal, was the court said that a hypothetical relocation was not a basis for measuring business damages. The Department of Transportation argued, Greg Costas argued for the DOT, that the department should be entitled to argue for a hypothetical relocation in the event that the business didn't choose to actually relocate. And the court said no, only when a business actually does relocate can you value business damages using a relocation calculation as opposed to a wipeout. So the courts basically said that under the duty to mitigate, or doctrine of unavoidable consequences, an owner was not required to relocate if they just chose to go out of business at that location as a result of the taking. So this case made about $1 million difference in this decision, because you have the difference between the department's claim and the business owner's claim, but it's going to have a lasting impact in how business damages are measured and calculated in Florida when you have a wipeout to a business. And you'll hear John Upchurch from California talk about business damage calculation later today. And in California, they have had the relocation method calculation for a lot longer than Florida has, so I think John will shed some light on that. The next case that is a seminal decision decided by the Florida Supreme Court is Walton County versus Stop the Beach Renourishment. This has been granted certiorari by the United States Supreme Court, as I said earlier, will be argued in December 2nd of this year. This is one of two cases we have today that deal with the hurricane that occurred in 1995, Hurricane Opal. What was happening as a result of Hurricane Opal was you had beach erosion in Panhandle beach areas, and as a result of that beach erosion, some legislation was passed that allowed the Department of Environmental Protection and other entities to establish what's called an erosion control line. And it was an artificial line that was used to set a fixed boundary between an owner who owned property abutting the Gulf and the Gulf. In the past, that line was always fluid. It would change. If